There are a couple different things that I wanted to talk about today with respect to estate planning. The first being that, kind of a general overview of what the documents look like, the ones that you're going to be putting into place when you're doing estate planning. And there's kind of a series of documents that you're going to want to put in place. The first is, for those of you who haven't engaged in this process, the first document that you're going to want to be looking to put in place is your revocable trust or living will. So I think most folks are familiar with the living will, or I'm sorry, not the living will, but the last will and testament. It's the document that talks about where your assets go when you pass away. It's kind of what we all think of when we think of those movies where there's a will reading and the family's huddled around finding out what happens now that the person has passed. In today's world, a lot of times people will use wills, but they will also use what's called a revocable trust, which is a will substitute. So basically what happens is that anything that passes under a will has to pass through a court supervised process called probate. It's not the end of the world. It is, most certainly the court sort of supervises the collection of the assets. They stay in through a creditor period of 6 months or so. The personal representative, who is the person appointed to execute the estate plan, pays off the creditors and kind of collects everything and maintains it. And then at the end of that 6-month period, assuming there's anything left over, it's distributed out to the named beneficiaries. So it's a process that has, it's a certain defined period of time. There are provisions within statutes to talk about who gets paid what and when and all of that. So it's not too overwhelming, but it is something that frequently. I didn't get that. Could you try again? Sorry. It is something that frequently people are trying to avoid just because they don't want the court being involved. It does require notice to sometimes extended family members. You have to publish a notice in the paper for 3 weeks in a row that the person has passed. So there's a lot of sort of administrative hassle that can go along with it. I guess we do love Siri. And so, and then there's that 6-month waiting period where maybe, you feel like you've covered all the creditors and you don't feel like you want to wait around for 6 months to see if anybody else comes out of the woodwork. And so for that reason, sometimes people will use this revocable trust, which has all the same provisions as will, but the probate process is really a process that's meant for the transfer of assets that have no other legal means of being transferred. So by putting assets into a trust, you give it another legal means of being transferred at death. And so that means then that you're not having to deal with the probate process. And that document can be beneficial in that it serves as a way to manage assets if you're incapacitated during lifetime. So it kind of serves as a combination of a will and a power of attorney. And so if you go to an estate planner and they're talking about this trust, I just want to kind of identify what it is and what it does and what it doesn't do. Because I think a lot of times people hear the word trust and they think, oh, a trust is for someone who has many, many millions of dollars. And, it's for tax planning and it's all of this and all of that. And it's really not. It is just it's a probate avoidance vehicle and an asset management vehicle. And it is something that's very common and something that can take the place of relying on a will. Okay, so those are kind of your major documents. And I just wanted to address really quickly kind of what are the advantages and disadvantages of those two ways of leaving your estate, just because that's going to be probably the first question that you talk about with your estate planner is what best fits my needs. So I've got a question here. No. So I got a question from asking if an irrevocable trust is the same as a living will. So 2 things that I want to address there. A living will actually has to do with your preferences for treatment in the event that you are incapacitated or otherwise can't express your preferences for healthcare purposes. So that's a healthcare related document that I'm going to talk about in a second. And I also want to mention that the trust that I'm talking about right now is a revocable trust. Which oftentimes gets confused. An irrevocable trust is a trust that you create and you can't change its terms. So that is the trust that you're thinking about for tax planning purposes. You can have an irrevocable trust even if you don't have many, many millions of dollars, but it is a tax planning vehicle. The revocable trust is a trust that you can change the terms at any time. And so that's why it doesn't provide A, any tax planning benefits, and B, it serves as a will substitute. I hope that sufficiently addresses that question. All right, so what's the best fit for you? So with a will, you're gonna have to do less legwork during lifetime because it just takes effect when you pass away, so you don't have to transfer any assets into this revocable trust. Sometimes practitioners will say it's less expensive because they don't have to draft both the trust, and if you have a revocable trust, you'll still have what's called a pour-over will. It's just a tiny little will that dumps assets into the trust that don't get transferred during lifetime. So because there's less documents, sometimes it'll be slightly less expensive. The disadvantages of will, obviously probate, you're going to have just the process. I know that, you know, if you have to hire an attorney to help with probate, that can be at least a couple $1,000s. And so it's going to be more expensive and more work on the back end for your beneficiaries. So less, you know, will is less legwork for you during lifetime, maybe more legwork for your beneficiaries at the end of the day. The will is also a public document, so it gets filed with public records and anyone can get access to it. So if privacy is a concern, you may want to consider a revocable trust. And then the other thing that a will, you know, the disadvantage of a will is, again, that it doesn't provide the means to manage assets during lifetime if you're incapacitated. So that's sort of the pros and cons of will versus revocable trust. And so that's going to be that first threshold question for you when you talk to your estate planner about what makes the most sense for you. When you are evaluating that, I should back up and say that we're talking about, you know, I say that we transfer assets to avoid probate, and I mentioned before that probate is a means of transferring assets that have no other legal means of being transferred. And so, like I said, the revocable trust is one way of ensuring that an asset has a legal means outside of probate to be transferred. The other ways that assets can transfer outside of probate and without a trust are if you own them jointly with someone. So joint tenants with rights to survivorship, if an account is titled in that way, then it's automatically going to pass to a surviving owner when you pass away outside of probate. So that's important to know because that means that it will, A, avoid the probate process, which is good, but it also avoids your will and your revocable trust. So if you had special provisions, let's say you own property jointly with your spouse and you wanted your half of that property to pass to your children from your first marriage. If you own it as joint tenants with rights of survivorship or tenants by the entirety, which is another form of joint ownership, it automatically passes to your spouse when you pass away. It doesn't matter what your will says. It doesn't matter what your trust says. And so that is a way that sometimes people, they'll title their property, or let's say they title property jointly with a child, but they really want that property when they pass away to be divided evenly amongst all of their kids. Again, that form of titling, that form of ownership is actually going to kind of accidentally defund their estate plan. So it's really important to understand that the way you title your assets affects whether or not they are subject to the terms of your estate planning documents. The other way that assets can pass at death outside of probate is by beneficiary designation. So if you have a retirement account or a life insurance policy, that beneficiary designation trumps anything that you put into your estate planning documents. So it's very important that your estate planner, when they're talking to you about what your estate plan looks like, what its parts are, how it's structured, that they're factoring in the fact that maybe some of your assets are not going to be subject to the will and revocable trust. And how do we make sure that everything works together? That is something that I've seen many times where people will accidentally defund their estate plan. They will put in place, let's say, you know, they'll put a lot of time into creating trust for their children, and then they will go ahead and just name the children outright as the beneficiaries of a large life insurance policy or their retirement accounts. And so unfortunately, those assets then when they pass do not pass to those trusts that they spent so much time on. They actually just pass to either a guardian or to the child at 18, which may or may not be what they intended. So what you want to talk to your estate planner about is what makes the most sense, will or revocable trust, and how do my non-probate assets intersect with and work with those documents and the plan that I put in place under those documents. I have another question, just one second. If a will is public as soon as it's filed, or does it become public after the person dies? Good question. So typically wills are not filed while you're alive. There is a registry that you can use. We infrequently do that just because you wouldn't want it to be public until you pass because you could change the terms at any time. So more often than not, you are not going to file your will until you have passed away and your personal representative presents the will for filing with the probate court. At that point, then, yes, it does become public. So more frequently than not, it's going to stay a private document of your own until you pass. All right. Oh, well, hey, look at that. All right. Great. Okay. So it looks like the Foundry staff is helping me out here, and we now have my materials. And if we could actually just go forward a little bit. Oh, wait, actually, go up. Sorry. Let's go back to, there should be, here we go. There we go. Okay, one more, go forward, one more. Or yes, perfect, perfect. Okay, so we just talked about this, the will irrevocable trust. So this is kind of the first component, and honestly, the major component of your estate planning documents. Okay, let's move forward one. Whoop, there we go. All right, so the next thing. So we talked about will versus revocable trust, what makes the most sense for me. The other documents that you're going to put in place as part of your estate plan, which are going to be pretty consistent regardless of whether or not you use a will or revocable trust, are a financial power of attorney. So this is a document that names someone to manage your assets if you're incapacitated or unavailable. So it can come up in a couple different ways. One being that, let's say you are in a coma or something like that, and someone needs to be able to pay your medical bills or pay your mortgage or, move money from one account to the other. That is something that this document is intended to allow your agent to do. The other thing would be, let's say you're just out of town. So frequently you'll have someone who, let's say in a married couple, they own the home jointly, they're refinancing their mortgage, somebody's out of town on a business trip, and so that power of attorney, again, comes in really handy to allow the spouse to sign on both. And this is a really important document to have in place in the event of sort of the unthinkable. I actually have a close friend of mine, his mother recently had a massive stroke, and now they are trying to sell the parents' home, and they have to go through a guardianship proceeding through the court to get his father appointed as his mother's guardian in order to sell that home. And all of that really truly could have been avoided by having the financial power of attorney. So I would very much urge you to have, even if you don't get around to getting a will or a trust in place in the immediate future, get a financial power of attorney in place. There are actually, Virginia does not have a statutory form, but DC and Maryland do. So those should be forms that you could very likely look up online. I think they might even be available through the Attorney General's office, their website, that you can just print out and sign and just name somebody so that somebody has control in the event that something happens. Now, there are two different ways that you can structure these powers, or kind of a general power. The first is durable. And by that, I really mean sort of a durable continuing power that becomes effective as soon as you sign it, and it stays effective until you pass away. The second is springing, meaning that it only comes into being if you're incapacitated. And typically your incapacity is determined by having at least one, but probably two or more doctors confirm your condition, or having a court order. Now, the downside of having it, typically in administration, actually using it, the first power of attorney is a lot more helpful because banks tend to be banks or financial institutions, or just even, any other business, tend to be a little bit hesitant to rely on a power of attorney because they're concerned about liability. Maybe this person isn't who they say they are. Maybe this document is fraudulent. And so they get very hesitant to accept these documents. If you then add into that document that it's only effective if you have two doctors confirm your incapacity, in my experience, most banks they're never going to take it. So more often than not, you're going to have an easier time using the power of attorney that is effective upon signature. The downside is then that someone could literally manage your assets while you're alive and have capacity to do so. And so sometimes, that could allow someone to move your assets or manage them in a way that you don't want them to. And it also can just provide people sort of anxiety about having that power of attorney out there. So you need to kind of weigh those two things when you're figuring out how to structure your power of attorney. One of the nice things about the trust is that, it kind of takes the place of, you still have a power of attorney just in case you need it, but it sort of takes the place of this power of attorney. And typically there are sort of more safety valves built in terms of someone being able to manage your assets if you don't want them to. So that's the power of attorney and kind of a description of how it might be structured. The healthcare power of attorney and living will, we just talked about this a few minutes ago. So the healthcare power of attorney, you name someone to make healthcare decisions for you if you can't make them for yourself. And typically it's subject to whatever your wishes are. So while you can express your wishes, you can override whatever your agent says. And then the living will talks about, typically we see sort of 3 scenarios that are provided under the different code provisions in 3 jurisdictions. If you are terminally ill and death is imminent, if you have an end stage condition, this is something that's Maryland specific, but I think is soon to be recognized in other jurisdictions. And that's something that's progressively debilitating. So if you think of Alzheimer's or ALS, and it's in its last stages, or if you're in a vegetative state. So if one of those 3 things is present and you have at least 2 doctors confirm your condition, that you're unlikely to recover, the death is just being prolonged, then in that event, you can, the agent can act on your preferences. So I think this is a provision that causes a lot of anxiety for people because they're worried that someone could sort of, they go in for allergies and someone tries to unplug them. That's not the scenario. To be legally effective, you really have to be in a state, in a very, in a state where you can't express your own wishes, and also that death is really imminent. And I would urge you to have a document, like I'd said about the financial power, I would urge you to have this kind of document as well, even if you don't have a will, just because this document is really even for more than yourself, for your family. It provides them some certainty of what you would want to have done. And it's a really sad and stressful position to be in, to try and make these decisions for someone if you've never had this conversation. So, there's most frequently under all the different jurisdictions, I think you have to have 2 people sign. And again, you have to have 2 doctors confirm for the living will. But there are not a terrible number of requirements for it to be legally effective. So I think you can find something online. Again, I think the Attorney General's offices typically have some sort of form. So if you're not working with a planner, but you just want to get something in place, you can look for something online. And again, this is more about having a conversation about what your wishes are to make sure that your family is aware of them and that they have some certainty in making those decisions for you if that time comes. Beneficiary designations are the next component for retirement assets and life insurance policies. And like I said before, it's really important that you address these, because these items, they control where these assets go. It doesn't matter what you put in other documents, it's what's listed on the beneficiary designation. So you want to make sure that it aligns. And also you want to make sure that your financial advisor or your estate planning attorney is talking to you about your retirement assets specifically, because who you leave them to can impact the income tax implications of those assets. For example, it used to be that you could leave them to a trust for benefit of children or a spouse, and they could take those assets out over their lifetime. That changed at the end of 2019. And so now there are different time periods by which the beneficiary has to take assets out and pay income tax, and it's all dependent on the terms of the trust. And so you really want to make sure that your beneficiary designations line up with your plan and that you understand what the tax implications of those designations are. The last component is an irrevocable life insurance trust, which used to be really, really common back when the estate tax exemptions were much lower. It is not so common now. This is probably a good time to go back and address the estate tax. So if we could go back a page. One more. This is just an example of a family, kind of generally what you would see. We can just address sort of the probate versus non-probate aspect. So we've got the jointly owned home, that's going to be non-probate. The individually held brokerage accounts, those are going to be probate. They are going to pass under a will or irrevocable trust. IRAs, they're going to pass pursuant to a beneficiary designation, non-probate. Life insurance, pass pursuant to a beneficiary designation, non-probate. Now, so we see generally what's in their probate estate at that first spouse's death. However, when you get to the second spouse, so let's say Pat passes first, now Parker is going to inherit the home, probably the brokerage account, the IRAs, all of that, then that's all going to become probate at her death. So that's another conversation that you want to have when you're talking about wills versus revocable trust. Sometimes I'll have clients who we start off with wills because they own everything jointly and everything else has a beneficiary designation. But when that first spouse passes away, now they need to reevaluate what's probate, what's non-probate. And a lot of times at that point, then we're going to really seriously consider putting in place a revocable trust. Okay, can we go up one more? Whoop, down one more. Down, good, okay, down. I guess I want to go forward. Down one more. Perfect, thank you. Okay, all right. So we talked about the components of estate plan. We talked about probate versus non-probate. Let's just talk a little bit about taxes. And this is kind of a moving target, and it has been for a while now. So on a federal level, right now the exemptions are at historically high levels. So it used to be that the exemption for federal estate tax was $1 million, and then it sort of slowly crept up to 3.5, and then it was $5 million. Right now it's $11.58 million per person. And between spouses, it's what is called portable, meaning if one spouse doesn't use all of it, it can pass, that exemption can pass to the surviving spouse. So a married couple right now can leave over $22 million, totally gift and estate tax free. That is scheduled to go down to, with inflation, about 5.7 million per person, and again, stay portable in 2026. Now that is all on the table when it comes to the election that's coming up. I believe Biden's suggestion is 3.5 per person. So again, we'd be going from 22 million to 7, so that's a huge drop. But for the majority of people, $7 million is going to cover them regardless. The state level, I think, so DC right now has an exemption of $5,762,400. So it's going to cover that amount. It is not portable. So this is one of the areas where if you have more than $6 million between a married couple, you want to make sure that there is tax planning in their documents to ensure that you can take advantage of both exemptions. Because if you have everything automatically past the surviving spouse at first spouse's death, there's a chance that you could lose out on one spouse's exemption and we could trigger a taxable estate. The only thing that you probably need to take away from that point is that if you have more than $6 million between you as a married couple, go ahead and make sure that your planner is addressing taxes and talking to you about the estate tax to make sure that they are incorporating that into your plan. Maryland, one other thing I want to note on DC is that right now the council is actually, I think they approved a drop to 4 million per person. And that is that's under a mayoral review right now. So we'll see if that comes into place. You're going to see a lot of changes, I think, statewide in estate taxes due to COVID and the need for funds in the states. Yes, thank you, Steve. We will definitely circulate these. I know I'm going really fast. There's just a lot to talk about. All right, in Maryland, $5 million per person, it is portable. And so you've got $10 million for a married couple and their ability to, you don't have to do any extra planning to make sure you can take advantage of that. If we want to scoot down a page. Oh, I guess I didn't address Virginia. Virginia has no estate tax, which might be why. So no worries there. I don't know if we have any Virginia people in the audience, but I'll address all 3 jurisdictions. Okay, so we talked about what all goes into our plan, how we're going to structure it, what are the taxes we're considering, what are, what's probate versus non-probate. So let's dig in a little bit more about what we're putting in our documents. So I'm not super familiar with sort of what the demographic is from your church, so we'll just kind of go through all of it. The appointment for guardian for children. So this is probably one of the #1 times that I see people coming in to get their estate planning documents put in place is when you have a child. And we immediately think, I have got to name a guardian in case something happens to both of us. And that's important because if not, then the court is going to do that for you. Again, something has to happen to both natural parents, but that's a really scary thought, I think, for most parents. So if you're in a position where you need to name a guardian, the things you want to think about, you're really naming someone to make the daily decisions for your child. So you want them to be able to parent in the way that you would normally parent if you were there. So I think of this more as sort of soft factors. People sometimes worry about making sure that this person is good at everything. I don't think they have to be good at everything. They just have to know your child, love your child. Your child has to know and love them, and they need to be able to live together and have a really healthy relationship. The other things you want to think about, proximity to you, or, sometimes I'll have people, they really want their guardian to move into their home so their child can stay in their school district or in their school, and that's totally fine. You can put strings on who you appoint. Age and physical ability to look after your kids. I have a 4-year-old and a 2-year-old. So, my mother-in-law, who is almost 70, is named as guardian, and we have an extra insurance policy to pay for a nanny because she would be exhausted running around after my kids. And so that's something to kind of think about is, let's say, again, sometimes one person isn't going to fit all of the things you're looking for. And so there are a lot of creative ways that you can deal with that. If their age or physical ability doesn't match with taking care of your children, again, you can get a really cheap term life insurance policy to help with that, to pay for the nanny or the au pair or whatever. And then preference in the event of a divorce or legal separation. People will frequently name married couples to serve as guardians. And the thing I always kind of say that like what I do is kind of the what if train. So if you name a married couple, what if they get divorced? What if one of them passes away? What if they move to a different state? Like you need to kind of talk through this and figure out how far down the what if train track you want to go and what are your preferences in the event that any of those things happen. Protecting a child's inheritance by leaving property in trust is our next factor. And so this is really important both for people who have little kids and people who have adult children. If you name a child outright, they will get that property at 18. Sometimes people, I don't think I was terribly great with money at 18. I don't know that I was terribly great with money at 22. And so the best way to protect your children from making mistakes with that property is by leaving it in trust. And there are a couple different ways you can structure that. You can structure it so that they get access, they get an automatic distribution of money at certain ages. Alternatively, you can structure it so that they can take money out, a withdrawal right, which also gives the trustee sort of one last bite at the apple to make sure that, if the child is they joined a cult and so they're withdrawing money so they can give it to the cult leader, the trustee can step in and say, no, I don't think we're going to allow for that. Let's revisit next year. And so that I typically tend to prefer withdrawal rights over direct distributions for that reason. Alternatively, you could just leave it totally in the discretion of the trustee, and that's going to provide the ultimate creditor protection for the child, which is important if they have creditors because of an addiction or certain, non-helpful habits, because of going through a divorce, because of a malpractice suit. So if creditors are a concern, you might want to think about leaving property in trust for a child for their lifetime, and then you just let the trustee distribute as and when it's appropriate. The other things to think about, a trust can be helpful if you have a child who's on public assistance for whatever reason due to special needs. That's a huge thing. If you have any beneficiary in your estate plan who's receiving government assistance or even private assistance based on means, you're going to want to consult with someone who is a specialist in that area because it's very tricky. To make sure that you are not unintentionally preventing them from getting that assistance. The other thing, the way that a trust sometimes, comes in place to protect children's interests is in a second marriage or third or fourth marriage situation, and that you want to provide for your surviving spouse, but you also want to make sure that they're not then leaving, all the money that you leave that to them, to their children from their previous marriage. And so a marital trust is sometimes the answer to that, and that you can provide for a spouse, but there's sort of oversight in terms of what happens with the remaining assets when your surviving spouse passes. All right, and one thing I wanted to mention too, when you have a trust for a child, one of the ways that's really great in terms of encouraging the child to increase their financial literacy, which I know is kind of a industry term, but it's pretty accurate in that they can, if you wanted to, you can name them as co-trustee of their trust at a certain age. So frequently, if I've got a lifetime trust, I will name the child as a co-trustee at 25 or 30. And then it requires them to be involved in the preparation of the tax return for the trust, or to talk to the trustee about how the assets are being managed. And so that's a way that you can the child still has supervision, but they are actively required and encouraged to be involved in that asset management and learning how to use the money and how to protect it and how to invest it. Okay, if we can go down a page. Great. Okay, other planning considerations. A reduction of tax burden. So if estate taxes are a concern, frequently it's going to be, state estate tax given the current levels for federal estate tax. There's going to be tax planning, again, using the DC estate tax exemption for the first spouse. You're going to want to make sure that you're doing that under your documents. Consider the income tax effects of estate inclusion. And naming a trust as a beneficiary retirement asset. So I mentioned this earlier, if you name certain trusts, it can affect how long your beneficiary can defer income on a retirement asset. So that's something that you want to talk about with your planner. With respect to the estate inclusion comment, that's any asset that's included in your estate for estate tax purposes right now gets what's called a step up in basis. So let's say I bought Apple stock when Apple first came out, and I've held it for 20 plus years. And of course, the value now is through the roof. So if I were to sell that asset, I'd have to pay tax on the difference between what I paid for it and what I sell it for. If it's included in my estate when I die, then the basis for income tax purposes is now its fair market value. So if my children turn around and sell it, they don't have to pay tax on anything because there's no difference between what they're selling it for and what the basis is, because it's the fair market value. So that's something to consider when you're talking to your estate planner, is that if you're leaving assets that have a lot of built-in gain that you've held for a long time, including, say, your home, you're going to want to talk to your planner about what are the income tax implications of how I'm leaving these assets and whether or not they're included in my estate. The creation of trusts, so you can put money into a trust while you're living to get it out of your estate so you don't have to pay estate tax on it. I don't think this series has a charitable giving section to it. So I do want to address charitable giving as a way to reduce tax burden here as well. So, if you are thinking that there's going to be an estate tax due on your estate, some other things that you can do are to obviously leave money to charity, and you can do that as just an outright bequest. So, I want to leave $10,000 to a charity of my choice, and you name that charity under your documents, and you're going to get a deduction for that. You could also name them as a residuary beneficiary. So, for example, let's say I want property to pass to my spouse for their lifetime, and then when my spouse passes away, I want the rest of it to go, whatever's left, to go to charity. And so again, that's going to create this charitable deduction and also help you achieve some of your charitable giving goals. There's also some really interesting but somewhat complicated trust structures that can also help you satisfy your charitable giving goals and generate deductions. So things called a charitable remainder trust and a charitable lead trust. And these are trusts that you can establish a charitable interest. So you give some part of the property, part of the income or principal of the trust to charity, and part of it goes to a non-charitable beneficiary. And there are some really interesting ways that you can generate income tax deductions, estate tax deductions, gift tax deductions. So to the extent that you are concerned about tax planning and you also really have a desire to benefit a charity, then I would highly encourage you to talk to your estate planner about what are the ways that I can, kind of incorporate all of this, because you could come out all the better for including a charity in your plan. All right, so the additional life insurance, this is something I really see a ton with young couples, especially. People think of life insurance as something to pay for the funeral, and it does so much more than that. I'm not an insurance advisor, so I would tell you that I would advise that you talk to a life insurance advisor if you feel like you need additional insurance. But from what I know, we should think of life insurance as an income replacement tool. So it's not just paying for one life event. If you have a spouse who is making, you're living on at least a portion of what they make, then we want to replace that for whatever we would normally see them make over the next 10, 20 years, especially if you've got a young family. And you can do that with a variety of different products at a variety of different price points, but it's really important to think of life insurance as kind of a backstop for keeping your current living status if something happens to a member of your family. The other thing it can do is supply liquidity if you need to pay taxes. So if we're thinking that estate taxes are going to be a big burden, or let's say, I don't know why you would necessarily have a huge income tax burden, but if you're thinking taxes are going to be paid at your death, life insurance is the way that you can provide that cash so that you don't have to sell, like, say, a business interest in a fire sale after you pass away. Typically you're not going to get the best value for an asset when you have to sell it under pressure in the next 30 days. So life insurance gives that kind of wiggle room. And then it can also be used to equalize beneficiaries. So for example, if I have an asset, like let's say I own part of a family business, and I want to leave that asset to one of my sons who has more of an interest in the business, has worked in that business, but I don't want my other son to feel like, he's getting cut out of his inheritance, right? So one of the ways that I can do that is to give him, I can buy life insurance so that whatever the value of my business is, my other son gets that same value. He just gets it in cash because, he's not interested in the business. And I certainly don't want my other son to have to pay to sell the business interest to equalize them. So that's one of the things that life insurance can be very useful for. Creditor protection is another thing that you want to kind of consider when you're putting in place an estate plan for yourself. So we talked about creditor protection for your beneficiaries, but so one of the things that I'll see is that people will need to kind of evaluate whether or not they care more about having their home pass through probate if they were to die simultaneously for a married couple, or whether they want to prioritize creditor protection because the form of ownership tenants by the entirety. And that's a form of ownership that's allowed only for married couples. And what it does is it provides some of the strongest creditor protection under law. And so, and it does that because a creditor of either spouse cannot come after property that's titled as tenants by the entirety. It has to be a creditor of both spouses in order to come after that property. So for example, if my husband and I own our homes together as tenants by the entirety, I get into a car accident, someone sues me for millions of dollars, they can't come after our home because it's titled as a T by E. Now, if I always like to use this is kind of an outlandish, believe me, this is an outlandish example, but we have a huge party at our house and people are doing keg stands on my deck and someone falls off the deck and sues both of us. They can come after my home because they're now a creditor of the two of us. But that seems rather unlikely for many reasons. Whereas, the car accident example could potentially happen. And, especially if you're with someone who, say, has sort of malpractice on their radar. So, a lawyer, doctor, things like that. So I will tell you that frequently when I have clients who are married and they own their home as T by E, tenants by the entirety, I just tell them to prioritize the creditor protection because I think it's so valuable. And I think the chance of them dying, going down in a plane together, or as a client of mine always likes to use, being eaten by cannibals together on vacation seems unlikely. So that's something that estate planning is so incredibly personal. You should definitely talk to your planner about sort of what your goals are, what your priorities are, what your assets are, what your liabilities are, what your risk tolerance is to figure out what's priority for you. Other ways in which you can protect against creditors: to invest in your retirement accounts. Retirement accounts are protected from creditors under federal and state law, so that's a really good place to sock away money. Contribute to 529 plans for children and grandchildren. That's great because it's protected from your creditors, it's held outside of your estate, and it also, if you create a 529 plan in your state of residence for income tax purposes, can give you an income tax deduction. And then the more complicated strategy would be to create a self-settled asset protection trust, which is only available in certain states, and that's a huge planning undertaking. So that would be something if you have millions and millions and you're really worried about asset protection, then you should definitely talk to your planner about that. Okay, question. Not about keg stands. How do you feel about deferred annuities for additional savings after maxing out tax deferred retirement? That's a really good question. Well, it's a really good way to defer income taxes. So you can essentially put money inside the annuity, it's invested, you can get, increase the value, it can appreciate without paying income taxes on it. And then when you finally pull money out, that's when you pay income taxes. So I think that's a really good strategy. I would note that that kind of strategy, you should definitely talk to your estate planner about it, but that's also a really good topic for a financial planner. So, and frequently in my practice, you have financial planners, life insurance advisors, and estate planning attorneys sort of all working together. And we can all each kind of identify, like, this is my wheelhouse, and, I am the person who can give you definitive guidance on this, but I really think you should talk to my colleague in this field to give you a little bit more sort of nuanced view. And like I mentioned before, that I'm not an insurance advisor. If I look at someone's asset list and, yes, me too. And I'm sure Jennifer will talk about that, the other Jennifer. Steve was just saying that they have a financial planning session coming up on the 15th, and I'm sure that she will talk about deferred annuities and retirement savings, and those are all really great topics for her to address as well. But so I guess one thing I would say is that if you have an estate planner who's trying to give you financial planning advice or life insurance advice outside of, hey, I see this issue, I really think that you should dig into this with someone who, you know, knows all of your assets and specializes, I would be concerned if someone is trying to do all of those things, all of those hats, because you can't be an expert at everything. So that's just kind of a little note that I would give to you, is that, you know, you want to work with someone who knows what they know and knows what they don't know. All right, back to, so we've gotten through creditor protection. Can you go down a slide? How to choose an estate planning attorney. So I get these questions a lot. Should I use estate planning software? And it's a hard question to answer because, like I said, estate planning is so personal. I'll tell you that a lot of times when I get calls from people and they tell me I have a really simple estate plan, I pretty much always know that they don't have a simple estate plan for a variety of reasons. You know, if someone, I'll tell you what sort of some of the hot button issues are where I'm like, you should definitely not use software. If you want to do planning that involves a special needs beneficiary, if you are potentially in a second marriage situation, if you have a lot of non-probate assets and you want to benefit a bunch of different people based on percentage, because that requires a lot of sort of integrating things that your software is very not likely to sort of identify or address. If you have a non-citizen involved in your planning, definitely work with an attorney because there's some complexity there, especially if you're dealing with a married couple where one is a non-citizen. If you have a taxable estate, I would definitely work with an estate planning attorney. Where I feel like software can maybe address your needs, you know, if you don't have a taxable estate, you literally just want to leave everything outright to your spouse or children, then you'd probably be fine to work with software. I would say that I see a lot of software can be sort of over-inclusive. You'll wind up with a farm trust, even though you don't have a farm. And sometimes it just doesn't identify sort of what are the things that you really want to dig into. I'd say that a good planner will talk to you about what your goals are, because planning can be a way to define your legacy and define your relationship with your family after you're gone. And so I think that there's a lot of reflection and thoughtfulness that needs to go into it. And a lot of times I think some of the best counsel that I give has nothing to do with tax planning. It doesn't really have anything to do with probate or any of that. It's, what does everyone else do? Well, I have this son and this is his scenario. Like, what do most people do in this situation? And I can tell you that. And I don't think that a software program could. So not to make a long story really long, I would use software if you have a simple plan, but I think it's frequently hard for a person to identify whether they have a simple plan. And truth be told, if you work with an estate planner, they should be able to tell you, like, I think that your needs, you know, I either am not sophisticated enough to handle your plan, or you might benefit from working with someone who does more, you know, not simple planning, but more straightforward planning. And so I would encourage you to at least talk to an estate planner and see what they might identify. And if they're worth their salt, they're going to tell you if they feel like you could totally benefit just from software, or if you would be better served working with another planner. Okay, can we go forward one? Can we go to, yeah, perfect. Okay, where do I find referrals for estate planning attorneys? So like I said, financial advisors, life insurance advisors, it's a very small community. We all kind of know each other. And so you can ask any one of them for referrals. And I'll tell you that, again, you know, even other estate planning attorneys, we refer business back and forth because if I'm too busy, or again, if I feel like it's not a good fit, I still want to make sure that person gets in the right hands, because I feel like you've trusted me enough to ask for my advice. And I think that's true for most, or at least hope that's true for most planners. So even if you have the name of a planner, you want to start there, and they hopefully will get you in the right hands. Neighborhood listers can be a good way to identify someone that other, your other friends and colleagues have enjoyed working with. Charities can sometimes have lists of planners that they have worked with in the past that they like, and who they feel like do a good job. And community estate planning presentations can be a good way to find people. Attributes, experience, responsiveness, that's a big one. It can be really hard to keep up with emails, I'll tell you. But I think that your plan is important to you, and I feel like your planner should recognize that and make you feel important as well. That being said, obviously, sometimes you need to give 24 hours before worrying that they haven't received your email. But yeah, I think responsiveness, it's much like finding a partner, right? It's someone that has the attributes that you're looking for. You feel like they respect you, you respect them, and it's a good working relationship. And that should all be sort of evident from the first meeting with this person, which goes to chemistry. And also sensitivity. This can be a really interesting topic in that it's very sensitive. There's a lot of family dynamics at play. You're also sort of grappling with your own mortality. So you need to have someone that you feel like you connect with, you feel like they understand you, you feel like they make you feel, and this is going to sound cheesy, but safe enough to be vulnerable, because talking about all this stuff can really make you feel vulnerable. It can put you in that place. So, I'm of the mind to say that, I would probably go less for where they went to school and more for how they make you feel. All right, we want to go forward one. When to revisit your estate plan? Another question I get all the time. So I like to think of this as like getting new tires or changing out your windows. You're probably going to kind of stay aware of your plan. I would read through it at least every year or two, just to make sure nothing major has changed. And you're probably going to do a total revamp of the plan every 3 to 5 years. Unfortunately, I think people sometimes think, I have a will, I am done. I never have to look at it again. And that's unfortunate because things do change. You're going to want to change it if you move to a different state. These documents are all incredibly state specific. So as soon as you move to a different state, even if it's from Maryland to DC or DC to Virginia or Virginia, Maryland, you want to check in with a planner to make sure that your plan still works. Like I had said earlier with the financial powers of attorney, those are state specific. They have actual statutory forms. So those are incredibly state specific. So at the very least, you're going to want to update those. Death of a family member, you might want to address if somebody passes, maybe their share should be distributed amongst the remaining beneficiaries in a certain way. The adding of children or grandchildren, any planner who's worth their salt is going to have a conversation with you about whether or not you want to include future children or future grandchildren. So hopefully, typically that doesn't require an update of your documents, but it's still important to kind of just check in. And again, your planner should be fine with you calling or sending an email and saying, hey, I just had a new grandbaby. Are they covered? Do I need to do anything? And have kind of that quick check-in call. Changing marital status is huge, because I think sometimes people think that a change in marital status will automatically trigger things under the documents. That's not necessarily so under state law, and it's definitely not so with respect to beneficiary designation. So it's really important to check in with your planner to say, hey, I just got married, or I just got divorced. What is this change? What do I need to update? Significant increase or decrease in assets. Hopefully it's an increase, because that's a happy reason to visit your estate plan. A change in estate and gift tax law, that's going to be less likely to trigger an actual update, but it's really good to check in with your planner. All right, so what approaches do you see to address future blended families, stepchildren, etc.? So there are a couple of different things, and probably the most popular planning strategy is the marital trust that I had mentioned earlier. So if I have, let's say, I have children from a prior marriage and I get remarried, and my spouse also has children from a prior marriage. Under my documents, I'm very likely going to leave my assets in trust to my spouse. And then when my spouse passes away, I have whatever's left passed back to, say, my children, or maybe I split it amongst all the kids, but by a different percentage, 75% to my kids, 25% to my spouse's children. I've also seen, I've seen people combine everything, but if there's like a different, one of the things to think about is, let's say the kids from the first marriage are a lot older. And so we've got kids from a second marriage who are a lot younger. We can talk about maybe putting property into trust for everybody's benefit while the young kids are going through college, or, until they hit a certain age. And then that's when we divide assets among all the kids equally. A lot of times under documents, I've seen this pressure to kind of divide property equally as soon as, somebody dies. And that may not be the best fit, because you might be then have, one child had college and law school paid for, and the other is in their sophomore year of college, and now all of a sudden their inheritance has to pay for their undergraduate education, which feels unfair. The flip side of that being that, the older kids might maybe you make a distribution to the older kids of a certain percentage when you pass away, so that they're not waiting forever, or whatever feels like forever for them, for their inheritance, while the younger kids are going through undergraduate or, reaching some milestones. So there's ways that you could kind of take into consideration making sure there's enough money in the pot to pay for younger family members, but also understanding kind of the impact that may have on older kids, and trying to make sure that, there's not tension, right? So having a common trust is really good while we have younger children that we're trying to make sure we preserve assets for. But at some point, you probably do want to divide it up, because we don't want the feeling that, my brother he's bought 3 houses out of this trust, and now there's nothing left, and I haven't really paid for anything. At some point, you don't want them to be tethered together asset-wise. You want them to sort of be independent and enjoy the ramifications of their own decisions. Other things, I'm trying to think of any other approaches or things that are important with stepchildren. I mean, I think probably the biggest thing is kind of identifying in your documents, who is your descendant, who is your child. Do you want your stepchildren to be considered your children? Do you want their children and grandchildren to be considered your descendants? All of that's really important to kind of map out. And I would say that there's no wrong answer. And I think that you need to be very honest with yourself and with your planner about your feelings about that, because the state law may include or exclude people that, based on your own value system, it doesn't match, that, you would want your stepchildren to be considered your kids, or you don't. And that's okay. But I think that you need to have a conversation with your planner and identify those issues and make sure that they're addressed in your documents, because the last thing you want is for there to be a legal fight amongst the kids when you're gone about what your intention was. And these documents are driven, when they're being interpreted by both trustees and the courts, it's all driven based on your intent. And it can be tricky, because if you don't have, evidence of your intent, then they're just that sort of arguing into the void of what you would have wanted. And so one of the things that I frequently do, and I think is a really great opportunity, is to leave what we call side letters or letters of intent. And you can use that. It's non-legally binding, but your estate planner just puts it along with your documents. And then if there are questions in the future, they have something to look to kind of explain what your thought process was. And that could be anything from, it's really important to me that you use this money for education. So as trustee, I want you to make distributions liberally for education, but not so much for fancy vacations. And you can kind of say like what your preferences would be for distribution. Alternatively, you could say, I want this money to be held in trust while they're concerned about creditors. If there are no creditors, anywhere that we're anticipating, please go ahead and distribute the money out and terminate the trust. And so maybe, that's how you provide your children with protection, but if it seems like it's unnecessary, the trustee can go ahead and just distribute everything out. Additionally, it's really important if you have someone that you are eliminating from your documents, and that happens a lot. And talking about chemistry with your planner, you need to be able to say, like, I love my brother to death. I do not want him to serve as trustee or guardian of my children because he makes terrible decisions. And then in this side letter, you can say, like, this is why I did this. I love you dearly. I just don't think you're a great fit for this position. And that's something too that can kind of be held and kept in the back pocket, and only released if it's needed. And so that's why I really like these sort of side letters as explanation and as support, to both the trustees, to your children. You know, I mean, you're not there to explain it. So it's really nice to have kind of a history of how you got to these choices and why you did what you did. The emotional issue of dividing tangible personal property. Oh, that's a great question. I don't know if I should, hopefully everyone's seeing this chat. So Steve has asked, what suggestions do you offer for how to address the emotional issue of dividing tangible personal property, including family heirlooms, jewelry, china, photos, paintings, etc.? Okay, so a couple different ways that we can address that. The first is, you know, frequently I'll see like, leave it all to my spouse and then leave it to my kids divided in equal shares, which is great. It can be hard to kind of figure out the value. The other thing too is that maybe there's stuff that, you know, I really want just this one item to go to my sister, or I really want this one item definitely to go to my daughter. In that situation, you can, in all three jurisdictions, you can actually leave a side letter, that kind of lists out what you want to go where and to whom. And that can be incorporated into the document as long as you sign it before you sign your estate planning documents. And again, that can be kind of that side letter can be put into the file, and it doesn't have to go to, like, for example, the IRS. So one of the reasons to do it through a side letter is that, you know, the IRS sees that I leave my, this painting specifically to my grandchild. They might say, well, why is it in the document? It must be worth a lot of money, right? And so they might have additional questions on an audit. Whereas if it's in a side letter, they never see that side letter. It just doesn't create an issue for further investigation from the IRS or otherwise. And it's also not part of the public record. So you're not sort of, assuming that you would otherwise put it in a will, you know, you're not going to be kind of highlighting that to other people, like, oh, by the way, he's got a Monet in his house now. The other ways that, you know, other things that are kind of helpful in terms of dividing up tangible personal property, we'll frequently do sort of round robins. So we'll say, okay, there are 3 kids, we've got all this property, everybody's going to draw straws, and the person who draws the longest straw gets to choose first, and the person who draws the middle straw chooses second, the person who draws the shortest draws third, and then the next round, the person who drew the middle straw draws first, and then the shortest, and then the longest, and then the third round, shortest first, and you kind of go through, and they select items until everybody's selected what they want, or, you know, there's nothing left to select from, and then the remainder gets either contributed to charity, sold, whatever. So you can do that through drawing cards, drawing straws. Those are ways that we will sometimes incorporate into documents to help people kind of figure out how to divide all of this. The other things that you can do are to have someone take photos of everything. Like, let's say you have beneficiaries all over the country, they can take photos, and this can be part of an appraisal process too, and then circulate the photos to everyone so that they can, rather than being in person and selecting, they can kind of just identify what it is that they would like. Okay, so I think the next page on so these are just the probate fees, and I think I just have DC and Maryland on here. I think Virginia is comparable. So you'll see they're not huge. I mean, you know, $5 million and over is the $2,300 for court fees. But in addition to that, you know, you have to think about your beneficiary having to take the time to go to the court, to file the petition for probate, if they need legal assistance to do that, what the attorney is charging. They have to, you know, send around notices to heirs and publish in the newspaper. And so it winds up being probably, I'd say, at least a couple grand to go through probate. And so that's something that can be avoided through the trust structure. And the other thing that I'll mention just within this, what's become sort of glaringly obvious with COVID, is that if the court is closed for some reason, or if their processing is held up, it can be really, really hard to get an estate open. So I've had a client who had a will, and they died in March, and we literally just got the estate open in like the past couple of weeks. And so it took well, I mean, 4 or 5 months to get the estate open because the courts have been closed. And so with a trust, that would not have been as big of an issue. And so that's just another reason, I suppose, to do a trust. Hopefully, this will not be a concern in the future. This will all get, COVID will be a thing of the past and we will never have to worry about this again. But it's just another thing to consider if you're kind of weighing trust versus will. The next page, I think, is just the Maryland probate fees. Yeah, so very similar, $2,500 for $5 million and over, almost identical. And then the next page is just my contact info. Do I suggest a joint account? Okay, so Steve has asked, do you suggest a joint account to ensure access to cash for burial, etc.? Yes, I would, realistically, a lot of times you'll have life insurance. Life insurance you can have paid out pretty quickly. You don't have to go through the probate process and you don't have to deal, if you have a trust, you automatically have cash, or should have cash, access to cash through that. You're just going to keep track of everything you spend on, the funeral, any sort of court fees and all of that, so that you can show that to the beneficiaries in terms of accounting for the trust assets. Or alternatively, if you're doing it for probate and for whatever reason the assets are frozen, someone can also pay those expenses and then submit for reimbursement, which will be approved. But yes, a joint account, like a small joint account, a life insurance policy, those are all assets that will almost automatically be available to the survivor, to the person administering the estate, and will be helpful for, I would think at least $10,000 for, all the funeral, for, just any sort of little things, paying off like the final little debts to make sure that they're not sort of pestering the person who's administering your estate. And again, anything that is paid for from, say, a joint account that should go as part of someone's inheritance, they can then submit for reimbursement for it. But it's just about having that liquidity to kind of really quickly deal with it.
I raised the question because of liquidity. I had a situation for Georgetown, actually, with a donor who was elderly in her 90s, and her family was all from out of the country. And when they came to do the burial and everything, the local funeral homes are not accepting, they're not going to proceed with the burial until you pay them, either card or check. And I was a little stunned by that. I kind of just assumed that, someone of this stature, and this was a woman with more than $5 million in assets, would not have this kind of situation where we're scrambling. I almost offered my personal credit card because the funeral home, which is a very respected funeral home, was not about to do this.
Yeah.
Being paid first.
Yeah. It's a really good point. I mean, again, that's kind of this sort of balance for liquidity is a important question. And it's something that I think, just to kind of go back to sort of software versus a planner versus looking holistically at your plan, and not just what it says, but how it will actually function when you pass away. It's an important thing to consider. And so that's something, then you kind of want to weigh the joint account, the life insurance, how does that play into who gets what, and the equal shares, and all of that. And something that can be helpful in terms of how you want it to be integrated is, again, a letter of intent, where you could kind of say, you could leave it with your will, like, by the way, I've left this account, I would like for that to pay for this, this, and this, whatever's left over, I want it to flow back into my plan in this way.
Got it. Jennifer, I can't thank you enough. This has been hugely informative, and this is what I spend my life doing. So I'm actually, every time I listen to one of these programs, and I will look forward to actually going back and re-listening to this and also going through the attachments, which we'll email out to everybody. But every time I listen to one of these, there is one more thing I take away and say, oh, I really need to remember to do that, because there are just so many details to take into account.
Yeah, I mean, it really is a process, and it's a hard one to prioritize because we all hope that we never need it. But it really, like I said before, I mean, you do this for the people that you leave behind, because on top of dealing with grief, you don't want them sort of chasing around various accounts or dealing with, an upset legal department at a bank. Like having this all buttoned up provides you with relief, and it really protects your family. And so it's important to get it addressed.
People have been generally quiet on the other And then I just wanted to reach out once more and ask, are there any other questions from the rest of the attendees that you want to ask Jennifer while she's online with us? I will, while you're thinking about that, I will say Jennifer and I had a conversation before she agreed to do the program, and she is actually heavily booked, and this may have changed since our conversation, but January is the first time that she has capacity, I think, to take on new clients, if that was something that's of interest. I will be seeing you in January.
Yeah.
So don't give away my spot.
Okay. And I apologize for my technological issues earlier. I've shared before, but my screen before, but clearly was struggling today. So thank you, Foundry staff, for saving the day.
No worries. I'm not seeing anything else flash up in terms of chat, so I'm going to assume that we are at the close. We've exceeded our 1 hour time by.
Sorry.
No. I was peppering you with questions which were self-motivated. So we will get the slides out to everyone after this. And just a gentle reminder that we do have Jennifer Meyer joining us in 2 weeks to talk about financial planning. And that's on the 15th of October at 10:30, same time slot, same station. And Lanny will once again, I think, be staffing us for that. So thank you again, Jennifer. We really appreciate your time and your expertise and your very, I call it laid back, but your very thoughtful approach to, well, what can be very emotional, and putting the time in now on the planning side makes what I'm going through right now easier.
Yeah. Well, it's my pleasure. And I'm happy to answer any questions if they come up later, something pops up. So.
We'll put your email contact in there, in with the slides as well, just so people have that.
Okay, great.
Thank you so much. Have a wonderful day, everybody.
Take care, everyone.